Hey there, Billy Terracio with Modern Law. And throughout the month of November, we are talking about co-parenting with an addict. Today, I want to tell you about a case called JF v. Como. And the issue here is a parent's mental health records and custody actions. As a little bit of background, the parties are going through a divorce. Father has been diagnosed with moderate to severe alcohol use disorder. At the time, mother requested father receive supervised parenting time based on his alcohol use. And she wanted him to sign releases allowing her to get access to his mental health and medical records related to treatment use. On a temporary basis, the court ordered that father would not have supervised parenting time. He would have unsupervised parenting time, but that he would have to participate in extensive daily and monthly alcohol testing, install a breath test machine in his vehicle, attend treatment, and continue therapy for his diagnosis. So, sometime later, father filed a motion to modify temporary orders, granting him equal parenting time and relaxing his alcohol testing requirements. The court granted his motion, father's motion, but also ordered him to release his medical records for the previous 5 years for an in-camera review. An in-camera review means the court would look at his records for the last 5 years and then determine what was relevant and what would be given to mom. Dad's lawyer filed a special action. So even though this was a temporary order, you can ask the Court of Appeals to get involved sometimes, and that's called a special action. So that's the type of case that we're discussing. And the question here is whether the Superior Court can order a parent to release his mental health records related to treatment for addiction for in-camera review by the judge in a child custody action to determine what records could be used for a custody evaluation. And we are balancing the privacy rights that you have and the privilege that you have under ARS 322085 versus ARS Title 25, or the best interest of the child, which specifically mentions both addiction and mental health. Parents do not forfeit their psychological patient privilege by requesting parenting time in a divorce or custody action. So just because you're in family court does not mean that all of your records are discoverable. So the court has to decide here when balancing between these two interests, the best interest of the children and the parent's right to privacy, who wins. And the court made it very clear. And here is a quote. "And so we make one thing clear. When a parent's privacy interest squarely conflicts with a child's best interest, the child wins." So what the Court of Appeals said is under the specific facts of this case, the parent's mental health and psychological records were released, presumably both to the other parent and to the court, but they did so for 1 year, not the previous 5 years. So the dispositive factor in all child custody disputes is the child's best interest. Arizona courts must safeguard that interest above all else, but there are still privacy concerns. So there's a couple of things that you need to keep in mind here. Father acknowledged he had alcohol issues. If in this case a party denied alcohol issues, it's possible that you would not be able to get someone's medical records or mental health records. The other thing is that father in this case had requested affirmative relief. So usually the issue of patient privilege is waived in a court hearing when the person places that issue in front of the court. So when father sought to modify the existing order by saying, "No, I'm good, these restrictions you put in place are not necessary," then father put that issue in front of the court, which makes it more likely that he would be ordered to give mental health records up. If instead he had not done anything, it's unclear whether the Court of Appeals would have still ordered that he sign the release of information. Finally, there are a couple of things that are important. There is a specific statute, ARS 25403.04, on the issue of alcohol abuse. It is a little different with regards to mental health, but 25403A5 references all mental and physical health of all of the individuals involved. So under this set of facts, we know that the court balanced the best interest of the children as more important than father's privacy interests with regards to his substance abuse, medical, and mental health records.